The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain everything you need to know about wills in Illinois and how they work. So a will is a legal document whereby the creator of the will, known as the testator, expresses his or her wishes as to the distribution of his or her property at her death. So the things that you can accomplish with a will include appointing an executor, and that's the person that is responsible for distributing your assets when you pass away according to the terms of the will. Beneficiaries are the people who will receive those assets, and you can also lay out instructions, and you should lay out instructions, as to how those assets will be divided among the beneficiaries. You can also lay out instructions for specific assets and specifically who they will go to. It's advisable to lay out contingencies. So if one beneficiary is not living at the time of your death, what happens to their share? You want to spell out as many contingencies as possible in the will. Finally, a will allow you to name guardians for your minor children should you be either due to mental incapacity or your death unable to care for them yourselves. In order to be legally valid, the testator has to be at least 18 years old and of sound mind at the time that the will was executed, and the testator has to execute the will in the presence of two witnesses who are also at least 18 years old and also of sound mind, and who also execute the will concurrently with the executor. A lot of people ask if they need an attorney to execute a will. You don't need an attorney. There's lots of places you can go online to get will forms, but it is highly advisable to use an attorney to execute a will. One reason is that it's not expensive. Attorneys don't charge a lot to do wills. They're not complex legal documents if you're an attorney. But it's advisable to work with an attorney because you can an attorney will help you avoid ambiguities and mistakes in the drafting of the will. Ambiguities and mistakes are problematic for two reasons, and they're very common if you're not using an attorney, but they're problematic, one, because your wishes might not be effectuated if your will is ambiguous as to what your wishes are if there's a mistake in the drafting. Two, because the court may not accept the will into probate, which again will make it so that your will is ineffective. But probably most importantly is that if there's ambiguities or mistakes in your will, this can lead to disputes and even costly litigation between family members that can really tear a family apart. So something as simple as not trying to do a will on your own and not noticing that there's a common drafting error that an attorney would pick up on can be a really devastating thing for a family. Another important reason to work with an attorney is that an attorney can counsel you as to whether a will is even your best option. A lot of people who come to me and say they need a will, I will tell them, based on what you have going on in your life, a revocable living trust is probably a more appropriate vehicle as the primary vehicle for your estate plan. Revocable living trusts do a lot of things that a will does, but also keep your estate out of probate when you pass away. An attorney can also talk about some of the other common goals of estate planning and fit them to your situation and see if it might also make sense for you to have financial and healthcare powers of attorney, living wills, and other ancillary documents that would go along with a will and a good estate plan. Next, let's talk about how to update a will. Updating a will is pretty simple. There's two ways to do it. One is that you can execute something called a codicil, which is basically a document that states which parts of your will you want to change and how the new language will read, and then you execute the codicil in the same way that you would execute the original will. If you're making wholesale changes to your will, it often makes sense to just revoke the will and create a new one. That leads us into how to revoke a will. There's three ways to do it. One is that you can destroy the will and all of its copies. The second way is to create a new will that contradicts the old will or explicitly revokes the old will. And the third is to execute a will revocation document. It's executed in the same way that the original will was and basically just says, I revoke the will that I executed on such and such date. Here we're getting into some more interesting questions that people ask. One is, will your estate avoid probate if you have a will? So probate is a court case that is often required in Illinois if you own any real estate at all, or if you have more than $100,000 in real estate assets, in non-real estate assets outside of a trust or outside of payable on death accounts. So a will does not avoid probate. People want to avoid probate because It takes about a year for your assets to be distributed to your family members. You're paying an attorney for this year-long court case, which can cost 5 to 10% of the value of the estate if you pick the wrong attorney. And it can be stressful for your family members, and it's a lot of work for whoever your executor is. A will doesn't avoid probate, but it will tell your executor and the court what your wishes are and allow your wishes to be effectuated in the probate case. That's why I say a revocable trust is often a more common estate planning vehicle that can better achieve most people's goals, because as long as when you pass away, all the real estate you own is actually owned by the trust, and you've got less than $100,000 in non-real estate assets outside of the trust or outside of payable on death accounts, then in addition to having your wishes effectuated, your estate will not go through probate. The trustee of your trust can instantly, if that's what the trust tells him to do or her to do, distribute the assets in the trust to your family members without hiring an attorney or hiring an attorney for minimal work, and there's no delay in transferring those assets. So it's a lot less stressful. A will doesn't avoid probate. It's still useful for many reasons that we're just about to talk about. But if you have the types of assets that would trigger probate, usually a revocable living trust is the best option. The next question and final question I'll answer is, if you have a trust, do you need a will? And this really depends on your situation. So I say a trust is often more appropriate as the primary vehicle of your estate plan, but sometimes it makes sense to have a will in addition to a trust, and this is called a pour-over will, because it deals with assets that pour over and are not included in the trust. The most common reason to have a will in addition to a trust is if you have minor children. The one thing that a will can do that a trust cannot do is appoint guardians for minor children. So that's often the most important part of somebody's estate plan if they have a minor child. So whenever someone has a minor child and a revocable trust is appropriate as the primary vehicle of their estate plan, I always suggest that they have a pour-over will. Another scenario in which you may want to have a pour-over will is if state statute differs drastically from your wishes as to how your assets will be distributed. And here's why. So in order for a trust to keep your assets out of probate, you have to properly transfer those assets into the trust. So if you pass away and you have some real estate outside of the trust or more than $100,000 outside of the trust, then whatever is in the trust is going to pass immediately through the trust outside of probate to who you want it to go to, or be held on and managed as the trust directs. But everything outside of the trust is going to go through probate. And if you just have a trust and not a will, then your trust can't automatically control the probate case. So whatever your wishes as stated in the trust are won't actually dictate what happens to the property that's going through probate. Instead, state statute called Intestate Law will determine how your assets are distributed in probate. So that's not the worst thing in the world. It's usually, if you have a nuclear family, it's usually what you would want to happen anyway. Everything goes to your spouse, then to your children, then to grandchildren, and then if there's no children or grandchildren or spouse living, then to your parents. So if that's what you would want to happen anyway, and you don't have minor children and you don't need to name a guardian, I will usually tell people a will is not necessary in addition to a trust. It's superfluous, you don't need it. But if you have vastly different wishes as to how you would like that property handled, this often occurs in the case of divorce. If you have minor children and you're afraid that your ex is going to get control of those assets because they're going to the minor children, you're going to want to make sure that your trust actually gets control of those assets, not your ex. Or if you've had a falling out with a family member, or if you want to give to charity. So really the two reasons to have a will in addition to a trust are if you have minor children and need to name a guardian, or if your wishes differ significantly from the probate statute and you want the will as a safety net in case for some reason you make a mistake funding your trust, transferring property into it, and there's some property that has to go through probate when you pass away. So that's everything you need to know about wills. We have a lot more articles about estate planning, wills, and trusts at learn-about-law.com, so check that out. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video posts. If this article left you with any questions, please leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.